The Senate Judiciary Committee will come to order today. It's Monday, February 23, 2026, and we do have a quorum present. We have one item on the agenda today, Senate File 473, but before we start with that, I'm going to read an announcement relating to committee decorum and expectations, which our security folks have asked us to read at the beginning of every hearing. I may not actually read it at every hearing, but certainly when we have a lot of new people here, I think, public observers, I think it's helpful to set the tone. So we appreciate your interest and participation in the legislative process. To ensure everyone can view, hear, and understand today's proceedings, we ask for your cooperation in maintaining decorum and civility throughout this hearing. For the safety, security, and comfort of all attendees, please note the following guidelines. Signs and placards are not permitted in the hearing room. Verbal outbursts, shouting, or disruptive behavior will not be tolerated. Disruptive conduct may lead to the removal of those engaging in the behaviors. Applause or other audible demonstrations are not allowed, and that includes finger snapping or things like that. For safety reasons, everyone must be seated. No standing, sitting, or pacing in walkways or aisles, and no standing or obstructing at your seat. If you require a reasonable accommodation, please speak with our sergeant staff. They are identifiable by the gold badges on lapels and suit coats and will be present throughout the hearing and are here to ensure everyone's safety. If there's anyone who still wishes to have a seat, there are several seats still available on this side of the hearing room here toward the front. I'm also going to state that I recognize that this particular topic is one of deeply felt emotions and beliefs on both or all sides of the policy discussion or debate. We respect everyone's right to have their own views and to express those views respectfully and to not be concerned about being challenged from the audience during the time they are expressing views if it's happening at the testifier table. We do not want to chill anyone's ability to present their viewpoints to the Senate committee. So I will be asking everyone especially to recognize that, and if you are feeling a strong emotion coming on and you need to take a deep breath, I encourage you to do so. I will probably be doing the same. Because a lot of us feel very strongly about these issues, and we do in fact respect that. So with that said, I'm going to note that we have identified testifiers who signed up ahead of time while the opportunity was available online as publicized by our committee. Each side, pro and con, the proposal before us today will have 30 minutes. And our staff will be keeping time. Because of the comparatively larger number of individuals that signed up to testify on the con side of the debate, and they have been informed, or the leadership there has been informed, that 2 minutes and 30 seconds will be allocated to each speaker. If we cut you off, it's not because we don't want to hear what you have to say. It's because we do want to hear what those who are following you have to say also. So please respect that, and I will try to be respectful about that. Kind of giving you either a nonverbal cue, like wrap it up, or if I have to, I'll just cut right in and ask you to wrap it up. So with that said, I will note that we do have packets, members of the committee, that have been distributed. There are additional comments and submissions that are included in those packets. I encourage you to take a look through those at your opportunity. It also includes the language of the bill and a bill summary. We are going to first hear from the chief author of the bill, Senator Kunesh, and for the record, as the chief author of the bill, she's not included in the 30 minutes for the pro side. That will start when our testifiers begin. Senator Kunesh, welcome to the committee.
Good afternoon, Mr. Chair and members. Thank you for giving us this opportunity to hear the Minnesota ERA amendment language. In Minnesota, we believe in freedom, we believe in fairness and equality for everyone, with no exceptions. The Minnesota legislature has a critical responsibility today to give voters the opportunity to enshrine equality into our Constitution through an Equal Rights Amendment. This amendment would provide clarity and stability to our legal system by guaranteeing that every individual, regardless of gender, identity, or other factors, is equally protected under the law. In this moment, more than ever, Minnesota deserves constitutional equality and a government that reflects the core values of fairness, self-determination, and democracy. In the face of real threats that we have all been experiencing, we must strengthen our institutions to ensure they remain representative, resilient, and trusted. This session calls for leadership that is thoughtful, principled, and grounded in service, and I invite you all to join me in this. Currently, assumed equality is just not enough. Courts have ruled that the 14th Amendment does not explicitly prohibit sex-based discrimination. To address this gap, we must ask Minnesotans to vote on a clear constitutional guarantee. And that would say, shall the Minnesota Constitution be amended to ensure that equality of rights under the law shall not be denied or abridged by this state or any of its political subdivisions on account of race, color, national origin, ancestry, disability, or sex, including decisions about pregnancy, gender identity or expression, and sexual orientation. This ERA will allow us to challenge discriminatory laws better, protect reproductive rights, and affirm Minnesota's commitment to gender equality. While some argue existing law suffices, constitutional assurance is essential to achieving true equality and dismantling systemic discrimination. This amendment is more than just legislation. It's a confirmation that ensures that all Minnesotans enjoy equal rights and protection under the law. Just a year ago, February 2025, polls indicated that 67% of Minnesotans support adding an inclusive equal rights amendment to the state constitution, and with 55% of voters supporting its placement on the 2026 ballot. This support is driven by concerns over protecting rights, with 49% of voters less likely to support legislators who fail to advance it. We know that democracy thrives when people have the choice in shaping their future. By passing the ERA amendment question, the legislature empowers Minnesotans to decide whether equal rights should be guaranteed under the law. At a time when fundamental freedoms are under attack, the ERA is our chance to reaffirm Minnesota's leadership on human rights and set a powerful example for our nation. And with that, Mr. Chair, I think we can move on to our testifiers.
Thank you, Senator Kunesh. We are going to start with Melissa Heising from the Minnesota AFL-CIO. And when she is done, Mai Thor. Did I pronounce that right? May Thor. Mai. I hope that's the only name I don't get, the only name I get wrong today, but it's probably not. All right, Ms. Heising, go ahead with your testimony.
Thank you, Mr. Chair. Mr. Chair and committee members, my name is Melissa Heising, and I'm Legislative Director of the Minnesota AFL-CIO. We are a voluntary, democratic labor federation representing over 300,000 members of over 1,000 local unions in the public sector, private sector, and building trades across the state. I'm here to speak in strong support of a state equal rights amendment. Minnesota AFL-CIO is one of the founding members of Minnesotans for Equal Rights. We are a coalition of over 25 organizations, including unions, faith leaders, disability justice advocates, racial equity leaders, LGBTQ+ communities, and the reproductive freedom movement. We came together to ensure our state constitution enshrines the strongest protections against discrimination and showcase Minnesota's leadership on human rights. The ERA would explicitly protect against discrimination based on race, color, national origin, ancestry, disability, sex, pregnancy, pregnancy outcomes, gender identity, gender expression, and sexual orientation. As a labor movement, we know these rights are deeply interconnected. We have seen how attacks on immigrant rights, reproductive rights, transgender rights, voting rights, union rights, and more all feed into and compound each other. When any group's rights are undermined, working people pay the price. Our fight for equality is shared, and every time we protect and expand fundamental rights, we strengthen our entire community. A constitutional amendment is the strongest, most lasting way to protect our rights. Statutes can be changed by future legislatures or reinterpreted by courts. A constitutional amendment provides a firm and lasting foundation. Ensuring equal protection under state law is enshrined and far harder to roll back. Minnesotans believe in freedom, fairness, and equality for everyone, no exceptions. We urge the legislature to swiftly pass the ERA, put it on the ballot, and trust voters to enshrine equal protection for all, once and for all. On behalf of the Minnesota AFL-CIO and the broader Minnesota for Equal Rights Coalition, we urge you to move this forward. Thank you for your time and consideration.
Thank you, Ms. Heising. Ms. Thor, come on forward. And after Ms. Thor will be former Representative Betty Folliard. And Representative Folliard, if you'd like to come sit in the other testifier seat, you'll be ready to go. Thank you. Ms. Thor.
Thank you, Mr. Chair and members of the committee. My name is Mai Thor, and I am the Chief Program Officer for the ARC Minnesota. Thank you for the opportunity to provide testimony today in support of Senate File 473. For 75 years, the ARC Minnesota has been fighting for the human rights of people with intellectual and developmental disabilities, or IDD. I'm sorry, I forgot my reading glasses, so I'm going to have to hold this up.
Plenty of us here can offer you ours.
Oh, that's perfect.
There you go.
Senator Kunesh and I have the same prescription. Thank you again for the opportunity to provide testimony today in support of Senate File 473, which would place a constitutional amendment on the November 26th general election ballot to have voters decide whether to pass a Minnesota Equal Rights Amendment. For 76 years, the ARC Minnesota has been fighting for the human rights of people with intellectual and developmental disabilities. We are a statewide nonprofit organization that has been instrumental in many policy and systems change efforts, including getting disabled people out of institutions and into integrated settings, and mainstreaming disabled students into public schools. We believe that people who have disabilities are inherently strong, powerful, capable, and resilient. The lived experiences of people with disabilities guides our policy priorities. I would like to speak to the essence and spirit of this amendment. Not only does Senate File 473 reaffirm equal rights protections for people with disabilities, it also sends a powerful message within our highest law, the state constitution. As Minnesotans, our individual human rights are our most inherent and fundamental. It only makes sense that the Minnesota State Constitution reflects how important this is. To have the human rights of disabled Minnesotans recognized in our state constitution means that we are seen as a community that has worth, dignity, and are valued members of our state. This amendment will positively impact everyone. Disability can happen to anyone, no matter what your background is, no matter what skin color you have, no matter what gender you identify as. Disability is an identity that intersects with all others. As a disabled Hmong woman, I know this to be true. My lived experience mirrors that of many other disabled people who identify as a person of color, an immigrant, or other marginalized identities. I know what it's like to experience discrimination based on my disability, ethnicity, and race. Giving the people of Minnesota a voice to speak up for human dignity by voting on this amendment to lift up protections in our state constitution allows people like myself and countless of others in our communities to feel seen equally. Again, Mr. Chair, thank you for this opportunity to testify today. Thank you, Senator Kunesh, and I'm happy to answer any questions that you might have.
Thank you, Ms. Thor. We'll now hear from Representative Folliard. Following her, Professor Hasday.
Thank you, Mr. Chair and members. I'm Betty Folliard, founder of ERA Minnesota, co-founder of Minnesotans for Equal Rights, and as a ruling elder in the Presbyterian Church, I can tell you that my faith teaches me that we're all equal in the eyes of God, or to put it simply, we are all worthy of rights, dignity, and respect. Minnesotans have been made acutely aware of late of what happens when our human rights under the law are eroded. I ask you to please pass 473, otherwise known as the Equal Rights Amendment, and an initiative prohibiting discrimination of any kind and establishing equal rights under the law as an unassailable principle in our state's strongest legal charter. Minnesota's state constitution is a dynamic document designed to be improved over time to reflect our ever-changing society. The inclusive ERA language acknowledges the pervasive nature of discrimination, helps dismantle structural inequities, and provides a foundational remedy to overcome these issues. By embedding constitutional protections in our strongest legal document, the ERA will secure remedies in our courts that cannot be easily eroded, while creating a framework for progress, both social, moral, and legal. In the spirit of the memory of those that we have lost in the past year, I ask for bipartisan support for this issue. In the last biennium, the late Senate Majority Leader Carrie Dietzich shepherded 2 ERA bills through the Minnesota Senate through the chamber with bipartisan support. And Speaker Emerita Melissa Hortman passed ERA 3 times through 3 biennia, separate biennia through the Minnesota House before being taken from us. Now is the time for this state to join the 29 other states that have already state ERAs in their constitutions by advancing this measure to the voters so that Minnesotans can decide whether to embed Minnesota values of freedom, fairness, and equality into our state constitution. The Reverend Jesse Jackson, who passed away last week, said, and I quote, "America is not a blanket, one piece of unbroken cloth, the same color, the same texture, the same size. America is more like a quilt, many patches, many pieces, many colors, many sizes, all woven together by a single thread. The white, the Hispanic, the black, the Arab, the Jew, the woman, the Native American, the small farmer, the business person, the environmentalist, the peace activist, the young, the old, the lesbian, the gay, and the disabled make up the American quilt," unquote. That's true here in our state. That common thread is our common bond, a belief in democracy, individual liberty, fairness, and equality. Whether you agree or disagree today with this bill, the vote you cast today on SF 473 will be to allow the voters to make a final determination, because everyone deserves the same right to the same rights. Thank you, everybody, and thank you, Mr. Chair. I hope you'll vote yes.
Thank you, Representative Folliard. We're now going to have Jill Hastay, professor at the University of Minnesota Law School, and following her, Cantor Tamar Havilio. Professor.
Thank you. Chair Latz and committee members, thank you for having me. My name is Jill Hasday. I'm a distinguished McKnight University professor and the Centennial Professor of Law at the University of Minnesota Law School. I teach constitutional law and sex discrimination, among other subjects. In my time today, I'd like to make one simple but fundamental point. The Minnesota Equal Rights Amendment is long overdue. Adding an ERA to the Minnesota Constitution is important for at least two reasons. Most broadly, passing a Minnesota ERA would be a powerful expression of the state's fundamental values. The ERA's explicit prohibition on government discrimination based on sex, race, disability, and other characteristics recognizes that no Minnesotan should be a constitutional afterthought. The ERA reaffirms that we all belong at the center of Minnesota's constitutional safeguards. We are all entitled to equal rights under the laws of this state. More concretely, adding the ERA to the state constitution would provide sturdier protection against bias. Unlike a statutory ban on discrimination, a constitutional amendment cannot be undone through ordinary legislation. A state ERA would protect Minnesotans for generations to come. 29 states, more than a majority, have already added equal rights amendments to their state constitutions. Minnesota should join them. Every Minnesotan deserves constitutional recognition of their equal rights. Thanks for your time.
Thank you, Professor. We'll now hear from Cantor Havilio.
Good afternoon, Chair Latz and members of the committee. First of all, I'm very honored to speak here. And I serve as cantor, which is kind of like a singing rabbi, if you don't know what that is. I get the fun job in the synagogue. And don't tell my rabbis that, though. And I am here today because my faith calls for me to stand for dignity, fairness, and justice of every human being. Let me start by saying that we are in the Jewish month of Adar, and Adar we are commanded to be joyous. It is the secret of Jewish survival, and it's the story of Esther that we read and chant from a week ago today in the holiday of Purim. We annually read the story of a Jewish princess who saves her people from the evil tyrant Haman. You're supposed to boo when I say that, who has decreed to kill all the Jews. This story also shows the belief that everyone deserves to be heard and justice will prevail over evil intentions to destroy our freedoms. In Minnesota, we believe in freedom, fairness, and equality for everyone with no exceptions. The Minnesota Equal Rights Amendment would embed the belief directly into our state constitution. As a religious leader, I understand the importance of foundations. Laws can shift, political winds can change, but a constitution is our covenant with one another. It is our brit in Hebrew. It reflects who we are and what we promise to protect for generations to come. The Minnesota ERA would guarantee equal rights for everyone by explicitly protecting against discrimination based on race, color, national origin, ancestry, disability, sex, pregnancy, and pregnancy outcomes, gender identity, gender expression, and sexual orientation. For too long, some communities have been excluded from full protection under state law. The ERA addresses this injustice directly. Some have asked why religion is not included in this amendment. The answer is simple. Our state constitution already provides the strongest possible protections for religious freedom. Article 1 guarantees freedom of conscience, prohibits religious tests for public office, and ensures that no religion is favored over another. The lack of religious language is not an omission of faith, but a deliberate effort to create universally applicable amendment that separates constitutional, civil, and legal equality for religious doctrine. As a cantor, I treasure religious freedom, just like Queen Esther. She had to risk her life to save her people from destruction. No people, no faith, no minority group, no disabled should be faced with any hate or discrimination that forces them to hide. The ERA allows me to serve my congregation openly and fully. Supporting the ERA does not diminish religious liberty, but instead affirms that the same constitutional respect should be extended to others who have historically been denied equal protection. So let's open our hearts and be happy in the month of Adar. Going forward, let us all be like Esther and not ever have to hide our identity, but rather rejoice in our many faiths, colors, cultures, traditions, and truly be free in the great state of Minnesota. It is past time to give Minnesotans a say in this fight for equality. Democracy thrives when people have a voice in the decisions that shape their lives. The legislature should swiftly pass the ERA now and place it on the ballot so voters can enshrine equal protection under state law once and for all. The Minnesota Constitution is our moral blueprint that reflects who we are. By passing the ERA, we make clear that our core values of fairness, equality, and justice are for all of us. The whole world is watching Minnesota. It's been watching us. It needs us. Please, please pass the ERA and bring this critical vote to Minnesotans. Thank you so much, and be happy. It's Adar.
Thank you, Cantor. All right, that concludes the testimony from those who signed up on the pro side of the issue. We'll now turn to the con side of this discussion here. We're going to start with Jamie Ali, and followed by Karen Adante. Hope I pronounced those things right. You're both welcome to come forward and take seats on either side of Senator Kunesh. We are going to start the 30 minutes, and a reminder, you each have 2 minutes and 30 seconds for your own testimony. Thank you. Whenever you're ready to start, Jamie Ali, go right ahead, introduce yourself, identify your affiliation, and provide us with your testimony.
Sorry. Good afternoon, everybody. I thank you for this opportunity today to testify. My name is Jamie Ali, president of Tainted, trauma-affected individual, not for transgender men, equally divided. Today, I don't come to testify before you as president of Tainted or president of anything. Today, I come to testify before each and every one of you as number 203069, Jamie Ali, former inmate of Shakopee Correctional Facility here in Minnesota. I'm here to testify before each and every one of you my experience while being housed in a facility designated as a women's prison. And I'm asking that you vote no to SF 473. Being housed in a facility designated for women, but including males, caused profound and ongoing trauma. I experienced intense panic attacks, withdrew from my classes, and turned to food for comfort, despite having a diagnosed eating disorder. This led to cycles of weight gain, distress, and misuse of laxatives in an attempt to regain control over my body. Daily routines, including showering and using restrooms with doors that did not lock, triggered constant fear that someone might enter and harm me. The presence of individuals I believe to be were predatory men, including those with histories of sexual offenses, left me hypervigilant and unable to sleep at night. The ongoing stress caused severe teeth grinding, resulting in dental damage. I also witnessed behavior in custody that heightened my fear and a sense of danger, such as reports of individuals identifying as transgender women engaging in sexual behavior with the incarcerated women. These situations intensified my distress and reinforced a sense of institutional failure to protect my safety. This environment triggered past sexual trauma, fueled nightmares, and worsened feelings of low self-esteem and helplessness. I felt ignored and unsupported by state leadership and corrections officials, which deepened the emotional harm and expanded the lasting impact of these experiences. During my incarceration, the living nightmare I lived and was forced to live was directly related to the housing environment. Every shower felt like a risk. Every trip to the restroom triggered fear. And every night I lay awake anticipating harm. This environment did not merely create discomfort. The psychological impact was acute and measurable. My ability to function, participate in rehabilitation, and maintain mental stability deteriorated.
I'm going to ask you to please wrap up, Ms. Zoli.
Okay, thank you. And so therefore, I'm not here as a political advocate, but as a woman who has lived through something that deeply harmed me. As a survivor of prior sexual assault, this environment did not feel rehabilitative. It felt like re-traumatization. Policy decisions made in this building do not exist in theory for us. They exist in concrete, steel locked doors, and in our nervous systems. Public policy must balance competing rights, but it cannot ignore the psychological and physical harm inflicted on incarcerated women in the process.
Ms. Zoli,
I
thank
lived
you
it,
for your
and I'm
testimony.
asking you to see it.
Thank you for your testimony, Ms. Zoli.
Thank you.
As you leave your seat to return to the audience, we'll ask Natalie Casper to come forward, and we will hear now from Karen Adante.
Yeah.
Did I get that right?
Yes, you did.
All
So
right.
good afternoon, everyone. I'm Karen Adante from Mendota Heights. There are so many issues with this so-called Equal Rights Amendment. It's more like a wolf in sheep's clothing, because while it promises equal rights for all, that couldn't be further from the truth. It excludes equal rights based on age, religion, conscience, and creed, and it erases protection for women and girls in the name of gender identity, the very people it supposedly set out to protect. It's actually the Unequal Rights Amendment. It would also give constitutional protection for a mother to abort her baby for any reason up until birth, including killing healthy babies carried by healthy moms, something that happens every single day, and that is heartbreaking. Next, the proposed wording is complete deception. You at least need to include the word abortion. The term pregnancy discrimination alone will deceive voters who won't understand it includes abortion up to birth for any reason. You know, I always thought when you share factual information, you could change people's minds, but seeing the truth so blatantly disregarded is incomprehensible when the truth is staring us right in the face. Abortion intentionally ends the life of a living human being. A constitutional amendment should never legalize killing innocent human beings. And while I grieve for the mothers harmed by abortion, often coerced and living with lifelong secret trauma, and the millions of babies killed and the generations of people that will never exist, I'm most sad for those who promote and legalize it, because we will each stand in final judgment before God, and I hope I can tell him I did everything I could to protect mothers and the beautiful lives he tried giving us, and I hope you'll be able to do the same. In closing, this amendment is deceptive, and it would be the worst thing that would ever happen to women, girls, people of faith, and the unborn. And like other injustices in our country's history that dehumanize human beings, if this bill moves forward, history will not look back on it kindly. Please vote no.
Just a reminder, even vocalizing words of support are not allowed during the testimony out of respect for everyone that is present in the room today. Thank you, Ms. Adante. Ms. Casper, you're next, followed by Reverend Witherington, who can come forward to the vacant seat there. Ms. Casper.
Hello, I am Natalie Casper. I attend River Valley Church. I'm a concerned citizen, parent, teacher, church volunteer, and ordained youth pastor in the state of Minnesota. I oppose the proposed Equal Rights Amendment to the Minnesota Constitution, Bill SF 473. I oppose the removal of religion or creed and the additions of pregnancy, gender, and sexual orientation to this bill. These changes would violate the religious beliefs of a variety of Minnesotans and the First Amendment, which enshrines our right to be able to practice our beliefs in religion publicly. The language in this bill is deceptive and misleading. Pregnancy means enshrining the right to premeditated murder of human life. This does not protect Minnesotans, it kills them. This strips away the rights of thousands of human beings every year in Minnesota. The #1 cause of death in the state of Minnesota is abortion, the premeditated murder of human beings. Murder is not a right. This is a violation against Minnesotans who believe that God alone has the authority to give life and take life, that every human being, especially the most vulnerable in the womb, are created with value and made in the image of God. Another deceptive term used in this bill is gender. This term, gender, according to this bill, is being used to destroy the bodies, the minds, and the lives of children and adults in the state of Minnesota through mutilation of healthy body parts, lying about the people's identity and their mental health conditions. This term is being used to violate Title IX, which is supposed to protect females in all spaces and places, especially bathrooms and sports. As a mother of 4 daughters, this issue is very close to my heart. I will do whatever it takes to protect them from males invading their privacy, their safe spaces, and stealing their trophies and titles. Minnesota has been failing to protect all biological female citizens by harming them instead. This violates the religious beliefs of Minnesotans who believe that God, the creator of humans alone, has the authority to define what a male and a female is, with a biological reality that reflects that objective truth through the sexual reproductive parts that God designed and gave to us for the purpose of human flourishing and procreation. And lastly, when does gender become a protected class? What are the implications this could have on parental rights? This bill is anti-female, anti-baby, anti-children, anti-religion, and potentially anti-parental rights. All Minnesota citizens should have their religious and parental rights protected and not be forced or coerced into saying or doing anything that goes against their beliefs or religion. Please vote no. Thank you.
Thank you, Ms. Casper. Karen Miller can come on forward, please, and we'll hear now from Reverend Witherington.
Thank you, Chair Latz. Good afternoon, members of the committee. My name is Dale Witherington. I'm one of your pastors here, and I'm the chief steward of Restore Minnesota, a Christian education ministry. And I'm here to speak in opposition of Senate File 473 as it is currently written. The fundamental issue at stake here is as basic as the content of our nation's Declaration of Independence and our Constitution. That issue is religious liberty, and contrary to my Jewish and Presbyterian colleagues who spoke so eloquently before me, this bill is yet another attempt to remove religious liberty protections from the 70% of Minnesotans who identify as Jewish, Muslim, Hindu, Buddhist, Catholic, Orthodox, Evangelical, mainline Protestant, historically black Protestant, Mormon, Jehovah's Witnesses, and more. In this proposed legislation, you are creating a new protected class of citizens, a class that is already protected, by the way. At the same time, you are eliminating the religious protections for individuals and organizations guaranteed by our Constitution. Is it really your intent to ignore and defile the doctrines of Jewish, Christian, Muslim, Hindu, Buddhist, and other religious faiths and put in its place the religion of the government of Minnesota? That is exactly what you are doing in this proposed legislation. You are replacing God and putting government in his place. You are violating the Establishment Clause of the First Amendment. You are violating the preamble of our own Minnesota State Constitution. The wording of this proposed amendment is misleading. It's misleading because, as we learned when this bill came up in a previous House committee, we were told it was written with the intention of removing religious liberty protections ethical Minnesota legislators have always fought to protect. Instead, after hearing from respected leaders in the Catholic, Protestant, Jewish, and Islamic communities, the main response came from a member of the committee by referring to these leaders and their religious faiths as disgusting. And it was disgusting not once, but she said it 5 times. The authors and supporters of this bill seem to be hell-bent on destroying the religious fabric of Minnesota, once a hallmark of this state. Then again, that is actually a publicly stated objective from another of our sitting legislators, namely the dismantling of organized religion. Well, that just ain't going to happen. If you want to demonstrate the principle of love thy neighbor, as the self-identified Catholic author of the House version of the bill testified, then please quit misleading the public with lies and deceptions. Loving thy neighbor means telling the truth, the whole truth. Please oppose SF 473 as it is currently written. Thank you.
Thank you, Reverend. Alicia Beckman can come on forward, and we'll now hear from Karen Miller.
Hello, Chair Latz and members of the committee. My name is Karen Miller. I'm a mother, teacher, and author of Faith in Action. Thank you for this opportunity to speak before you today to highlight constitutional concerns in this proposed ERA. Certainly, we can agree with the initial statement in the bill in line 1.9, quote, all persons shall be guaranteed equal rights under the laws in this state, end quote. Indeed, the rights of all persons are already protected by our Minnesota Constitution, which states, quote, government is instituted for the security, benefit, and protection of the people, and no member of this state shall be disenfranchised or deprived of any of the rights or privileges secured to any citizen thereof, end quote. Since our Constitution already broadly protects the rights of all people, this proposed ERA is unnecessary. Furthermore, the Constitution does not give you, members of the legislature, the right to classify the people. The minute you start listing protection for only some characteristics such as A, B, or C, you have instantly discriminated against all others not mentioned such as D, E, and F. Therefore, this ERA is a discriminatory violation of our state constitution and would be more aptly titled an unequal rights amendment. Most notably, protection for religious liberty is completely missing from the proposed language. Our first president, George Washington, said that religion and morality are indispensable supports of our nation. The right to religious freedom is a sacred foundation that all our other rights stem from. No serious legislation claiming to protect the equal rights of all can be drafted without it. The way this ERA is worded, there's absolutely no protection for a person acting on the basis of their conscientiously held religious beliefs, yet it enshrines abortion and gender identity rights. This is a flagrant violation of our Minnesota Constitution, which states in Article 1, Section 16, quote, the right of every man to worship God according to the dictates of his own conscience shall never be infringed, end quote. Of additional concern is the deceptive language on the ballot. When a voter sees the word pregnancy, they will think they're voting to protect the vulnerable, pregnant, and unborn, while they are actually voting to enshrine the right to kill the unborn. This is a deceptive manipulation of the conscience of the people. Passage of this Equal Rights Amendment will ironically result in gross violations of the rights of the people as protected by the Minnesota Constitution, which you swore an oath to support. Do not violate the public trust. I urge a no vote. Thank you for your consideration. Thank you.
Thank you, Ms. Miller. Is Alicia Beckman in the room? No. All right. If we'll call the name one more time before we conclude this portion of the hearing, just in case she comes back. Teresa Collette, you want to come forward, Professor? Welcome back to the Judiciary Committee. And then following you, Renee Carlson. So Ms. Carlson can also step forward and grab a seat. Professor Collette, go ahead.
Chair Latz, members of the committee, and other distinguished guests, it's a pleasure to appear in front of you again. I respectfully urge you to vote against Senate File 473. As is previously stated, equal protections under the law is already ensured and guaranteed by Article 1, Section 2 of the Minnesota Constitution. This legislation is intended not to enhance that protection, but actually to undermine it. The Equal Rights Amendment at the national level was first proposed in 1972 when women undeniably lacked important legal protections. But that's no longer the world we live in. Over the past decades, Congress, state legislatures, and courts have dismantled the legal barriers and enforced robust protection against sex discrimination. The results are undeniable. When we look at the actual instances of discrimination cited in at least the published testimony for this hearing, we find that there are only two. One, a story from 1960, which has been corrected multiple times by federal legislation, and the second by the claim that that Minnesotan women earn only 81% of every dollar that men earn in this state. It is true that in 1970, women comprised 37% of the labor force, and today women comprise over half. Prime working age women are participating at record levels. Educational attainment has quadrupled. Women now make up a majority not only of college students, but law students and medical students in this country. Women earned approximately 60% of every dollar that men earned in 1960. Today, the national figure is 84%. But those differences are largely due to the employment choices that women make and the majors they choose to pursue when they go to college. Women now own approximately 40% of American businesses and more than 1/3 of Minnesota businesses. Senate File 073 is not a simple equal amendment. It is a sweeping constitutional revision that embeds contested political concepts, including gender identity and what's called reproductive freedom, into the Minnesota Constitution. I disagree with the professor from the University of Minnesota in that she suggests that these are common fundamental values of all Minnesotans. I agree with her that constitutions are meant to establish enduring principles of governance, but not to lock in divisive policy debates of the moment. Once constitutionalized, these issues will no longer be resolved by our elected representatives accountable to the people. They'll be decided by the courts. This amendment risks eroding longstanding sex-based protections in areas such as women's athletic, privacy spaces, and as was testified earlier, even our prison system. It risks generating conflict with religious liberty, protections explicitly guaranteed in Article 1 of our state constitution, and it removes abortion policy entirely from the democratic process.
Please finish up, Professor.
Minnesota law already protects against sex discrimination. The Constitution should unify, not divide. I urge you not to advance Senate File 0473. Thank you.
Thank you, Professor. If Rebecca Delahunt is in the room, come on forward. And Renee Carlson, please identify yourself and your affiliation and provide us with your testimony.
Good afternoon, Chairman Latz and members of the committee. My name is Renee Carlson. I serve as General Counsel for True North Legal. Senate File 473 creates the problem it claims to resolve: inequality. It undermines long-standing legal protections. Today, I will address two: protections for people of faith and women and girls. Members, we've been here before. This committee passed a law stripping protections for houses of worship and people of faith, which I testified in that committee about 2 years ago, but you later restored them with bipartisan support. Omitting religion as a protected category sharply reverses this law, prioritizing gender identity protections over religion in the state constitution, even if the Constitution already protects religious liberty. Senate 473 gives judges a blank check to form new forms of discrimination, subjecting people of faith to relentless lawsuits and civil rights complaints simply for adhering to their faith and beliefs about men and women. Guaranteeing equality for women and girls matters, but this amendment is both unnecessary and damaging to their future. As was mentioned, and I'll reiterate, Article 1, Section 2 of the Minnesota Constitution already prohibits sex-based discrimination, but this amendment would eliminate the court's recognition of those sensible distinctions. The proposed language would expand the definition of sex discrimination to include discrimination on the basis of gender identity or expression. Anyone who feels like a woman or a girl is one. Women and girls are thus reduced to the stereotypes the people behind this bill claim to be fighting against, forcing women and girls to fight for their very existence. Even without the ERA, males have increasingly overtaken women and girls' categories and spaces. The Minnesota Supreme Court held that USAPL can no longer have female-only categories and males can win their trophies. A nonprofit housing female sex trafficking victims was forced to house males or give up their state grant. And I'll never forget our clients, high school girls, who wore plain clothes under their gym clothes just to make sure they had privacy in their own spaces and that males could not access those spaces. I could provide more examples, and I hope to hear from the ERA advocates here today about how their bill answers these issues. There's a real cost to pretending biology is optional, and it's women and girls who are paying the price. The path to equality demands that we embrace reality, and this bill does not do that. Thank you.
Thank you, Ms. Carlson. If Maggie Hangy wants to come forward, and then we will now hear from Rebecca Delahunt. Please identify yourself and your affiliation.
Chair Latz, Senator Kunesh, and members of the committee, thank you so much for having me. My name is Rebecca Delahunt, and I work as Director of Public Policy with Minnesota Family Council. The ERA would amend Minnesota's constitution to include, quote, "The state shall not discriminate against any person in intent or effect on account of gender identity or gender expression." Under this language, the Minnesota Constitution would protect rejection of sex. In practice, what does that mean? It's likely this means that the Constitution will protect sex-rejecting procedures, or so-called gender-affirming care. These practices are in question in the medical community, both globally and in the United States. On February 3rd, 2026, the American Society of Plastic Surgeons stated, quote, "The overall evidence base for gender-related endocrine and surgical interventions is low certainty, and in light of recent publications reporting very low or low certainty of evidence regarding mental health outcomes, along with emerging concerns about potential long-term harms and the irreversible nature of surgical interventions, ASPS concludes that there is insufficient evidence demonstrating a favorable risk-benefit ratio for the pathway of gender-related endocrine and surgical interventions for children and adolescents. Creating constitutional protection of low-certainty medical practice is not sound public policy. We should know if that is the legislative intent of ERA. The so-called ERA expressly creates constitutional protection for so-called gender identity, likely forcing females to share private spaces such as restrooms, locker rooms, and dorms, state grants, scholarships, athletic opportunities, prison facilities, and women's shelters with males who identify as female. We believe ERA would give constitutional protection to males' access to female prison in Minnesota. Margot G. Lewis is convicted of homicide. As of today, February 23rd, Margot Lewis is housed at MCF Shakopee. A DOC source reported, quote, "Lewis still has male anatomy. I believe this inmate is dangerous both to the physical safety and emotional well-being of others. Lewis has been approved to have his strip searches done by female staff only," end quote. Elijah Berryman, a male convicted of criminal sexual conduct, and Bradley Richard Servio, serving life for homicide, are housed at MCF Shakopee as of this morning. That's not a conclusive list. One incarcerated woman at Shakopee, called Janice, shared with Redux, quote, "Like most inmates, there is a fear of speaking up or voicing those concerns because of potential retaliation or because people will think you're being discriminatory or judgmental." Incarcerated women housed at Shakopee now face high risk of sexual violence, a punishment which was not part of their sentencing. That is a barbaric injustice. Women and children bear the consequences of a society which allows for the rejection of sex. Legislators may attempt to erase reality by legislation, but these attempts fail, and women and girls and boys bear the consequences. Who will be the voice of justice for women and children? Please vote no on SF 473. Thank you.
Thank you, Ms. Delahunt. And Kathy Blazer can come on forward, and we'll now hear from Maggie. How do you pronounce your last name?
Hangy.
Hangy.
Yes, thank you.
Please identify yourself and your affiliation for the record.
Chair Latz and members, my name is Maggie Hangy. I'm here from the Minnesota Catholic Conference. The Catholic Church opposes and forcefully rejects unjust discrimination in all its forms, such as racism, sexism, and ableism. Discrimination is the exclusion of people from the social, political, and economic life of society based on some personal trait or characteristic. In our work as the largest non-governmental provider of educational, charitable, and healthcare services, locally, nationally, and internationally, we seek to ameliorate discrimination by serving those in need, not because they are Catholic, but because we are. Discrimination on a wide variety of classifications is already banned under the federal and state constitutions, as well as in federal and state statutes such as the Minnesota Human Rights Act. So why do we need the Equal Rights Amendment? We don't. The purpose of the ERA is the coercive imposition of the most discredited, harmful, and unscientific ideologies of sexual politics via the executive and judicial branches, and it encourages the punishment of those who dissent. It's an end run around the legislative process for policies that are politically untenable. First, it strengthens constitutional protections for abortion and assisted reproduction, will require state funding of both, and makes it difficult, if not almost impossible, to put legislative limits on these practices. Second, It imposes discredited gender ideology that, among other things, will likely require public funding of various accommodations, could lead to the punishment of those who, for example, misgender someone, and will make sex-specific spaces and programming illegal, such as in public shelters, prisons, and women's sports. In other words, it threatens free speech and the right to safety in one's body and one's person. Finally, by not providing protection against religious discrimination, it will leave vulnerable those who oppose these harmful ideologies and understandings of the person and sexuality, as well as unpopular religious minorities. The ERA is the Erosion of Rights Amendment for women and people of faith. The ways in which this amendment will be abused will depend on the creativity of state officials who, under the color of non-discrimination principles, will impose policies that they believe will eliminate the effects of discrimination, regardless of intent, including the exclusion in licensing, public contracts, and state funding of those who hold traditional views on human sexuality. Its main purpose is to be a sword against those who oppose a sexual revolution, not to shield people from unjust discrimination. Not every distinction is discrimination, and biology is not bigotry. Please oppose this unnecessary and harmful amendment. Thank you.
Thank you, Ms. Hangy. And our final testifier here, Kathy Blazer. Please go ahead and identify yourself and your affiliation.
Thank you, Chair and members. Kathy Blazer, Minnesota Citizens Concerned for Life. In a reprise of 2024, this bill once again conceals abortion up to birth in innocuous language and attempts to dupe Minnesota citizens who overwhelmingly oppose unlimited abortion into unknowingly voting for just that. This bill proposes that discrimination should not be allowed based on a person's pregnancy status. Of course, we all oppose discrimination against someone based on the fact of their pregnancy. But the actual legislative policy this referendum would put into our Constitution goes much further, providing a fundamental right to make decisions about remaining pregnant, a fundamental right to abortion for as long as a person is pregnant, with no protection for babies at any gestational age, including healthy, viable babies. 68% of Minnesotans consistently say that they want reasonable protections for babies who feel excruciating pain and could just as easily be delivered alive and thriving rather than aborted. Abortion advocates know that if they were truthful about what they are trying to push into our Constitution, Minnesotans would vote a resounding no. In the 2024 legislature, citizens made this no heard throughout these halls in visits, phone calls, rallies, emails, and texts. Yet once again, we have an apparent strategy to dupe Minnesotans into voting for something they overwhelmingly oppose. This bill cloaks abortion up to birth under the guise of pregnancy, permanently enshrining unlimited abortion in our Constitution, because abortion advocates know that they cannot win an honest discussion on this issue. MCCL will not allow this horrific lie to go unknown. We will continue to do everything it takes to ensure every Minnesotan understands the deceit of the abortion industry. Nor will we allow Minnesotans to lose their rights of conscience, faith, creed, and belief. It is clear this current language does not advance true equal rights for all Minnesotans. Instead, it threatens the rights of those who disagree with its agenda, robbing them of the rights that are the bedrock of our nation.
Please finish up your testimony, ma'am.
At a time when our legislature should be careful to avoid the appearance of fraud or deceit, hiding unlimited abortion in a constitutional amendment is not the conduct of a trustworthy branch of government. Minnesotans will know the truth of this abortion up to birth amendment, and they will once again come out in droves to defeat the lies behind it. Thank you.
Thank you, Ms. Blazer. I'll call the room one last time to see if Alicia Beckman is present to testify as she signed up for it. I don't see her coming forward, so we will close this portion of the testimony and the hearing today. Just a heads up, the committee is scheduled to end our session at 2:30. I'm planning to be concluded at that time. But now what we're going to do is open up the floor. If there are any questions, I think what we'll do is have questions of the author, Senator Kunesh first, and then once we've concluded that, we'll consider amendments, have discussion. If there are questions of others who testified, that would be okay too, but we want to try to keep that those questions and answers a little more limited so we have time to have ample committee discussion as well. So are there any questions from members of the committee for our chief author, Senator Kunesh? Senator Verbatim.
Thank you, Mr. Chair. Not really a question, but just a comment, and thank you for bringing forward the bill, Senator Kunesh. But I think it's important to recognize that we would be bringing this to the voters. So all these questions before us are really going to be up to Minnesota voters on if they deserve, everyone should have equal protection under the law. So this is the first step in then bringing that question to the voters. That's all. Thank you.
Are there any other questions for Senator Kunesh at this time? Senator Kroon, then Senator Westrom.
Thank you, Mr. Chair. Can you just kind of walk us through the changes from the bill from 2 years ago and why the changes were made?
Senator Kunesh.
Thank you, Mr. Chair. I don't have the language of the past one here in front of me, but the whole point of the changes that we put into here are the result of a number of different organizations and discussion for a number of months in order to make sure that we have probably the most inclusive and the best coverage of those members of our communities, of our society that don't have the protections. And so as we went forward, the language that you find now is probably the most inclusive.
Senator Kroon.
Thank you, Mr. Chair. On lines 1, 10, it says the state shall not discriminate against, and then it goes on to do the list. As the chief author of this bill, do you envision any circumstances where the state could be defined to include a non-government organization, such as one that might receive public funds, maybe they're licensed by the state, or they serve as a government contractor? Do you anticipate that the language in this amendment would apply to them as well?
Senator Kunesh.
I'm afraid, can you just explain that a little bit clearer, please? Thank you.
Senator Kroon.
Thank you, Mr. Chair. When it says the state, which is 1-9 through 110, shall not discriminate, my question is whether you envision any scenarios where the state in this proposed amendment could include non-governmental organizations that receive public funds, are licensed by the state, or serve as a government contractor.
Senator Kunesh.
I am going to turn it over to one of my helpers here, and if you'd like to respond to that, would be great.
Go ahead and identify yourself for the record.
Sure. My name is Jess Braverman, and I'm the legal director at Gender Justice. In regards to that question, there is case law on whether and when a private entity can be considered a state actor, and I would assume that case law would apply. Receiving public funds is not enough to meet that burden. There has to be more to it. So someone's conducting a government function. You don't want a situation where the government just hands over all of its responsibilities to a private party and then says now the same rights no longer apply. But there's a analysis that courts do in determining whether and when private parties qualify as government actors for constitutional protections. But in terms of receiving public funding and licensure, those two things on their own would not likely be enough.
Senator Kroon.
Thank you, Mr. Chair. It sounds like there are some scenarios under existing case law where the state could include non-government organizations, depending on the circumstances and their relationship to the state. So Another question I had is, and maybe I would need to, and maybe you could help answer this, or another person could be Teresa Collette possibly, because it's illegal if she's still here. I don't know if she could come back up, if you wouldn't mind.
Professor Collette, come on up.
We heard a lot of testimony about religion being excluded from this amendment. And the testimony in favor of the amendment suggested, well, it's already in the state constitution, and that's why it's not in this bill. So maybe both of you can give me your perspective on the interplay between Article 1, Section 16 of the state constitution, and the language in here about shall not discriminate, and how those two sections of the state constitution might work together, or how you think a court might interpret that in real-life situations where you have religious organizations and that sort of thing. If you could just give me your thoughts on that.
I think.
Ms. Braverman.
Oh, thank you. Sorry. That's a really good question, and it's something lawyers can just spend so much time arguing and debating, and ultimately some of the questions might have to reach the courts before we find answers. However, right now the Minnesota Constitution protects religious liberties to a greater degree than the federal Constitution. We probably have some of, if not the most protective Constitution in that regard. It's not only this, but Article 1, Section 16 is a really robust, it's one of the longer amendments in Article 1, and it covers religious liberties from so many angles, including equal treatment, including, and I have a quote because I think it's actually a really nice quote, the right of every man to worship God according to the dictates of his own conscience. And so that's in the Constitution. That protects religious liberties. It's very clear. You can have religious tests for government. So for example, I'm Jewish. You can't say, well, you can't hold a government office because you're Jewish. That's in the Constitution. The right to free speech that's in the Minnesota Constitution applies to religious liberties as well, the right to express religious liberties. So that's in there already. That's really robust, explicit protections that are already in there. There's a section at the bottom. I don't have the line numbers with me. I just printed out my own copy of the ERA language. This section does not limit or narrow existing rights in this Constitution. And so the language in the ERA shouldn't really change Article 1, Section 16. What it does is it provides more people with protections who don't have those robust protections that religious folks have enjoyed since the founding of the state of Minnesota. So it really brings more people in and provides more people with protections, but it does not limit or narrow existing rights. That line is explicitly in there. I thank you. It's 2.7, I believe, is where it starts, based on the version I have here. It says this section is self-executing, and then this section does not.
Senator Kroon, did you wish for Professor Collette to respond to your question as well? Professor Collette.
Mr. Chairman, while my friend has properly articulated the standards under the Minnesota Constitution, we need only look at the docket of the United States Supreme Court the past 5 years to see the conflict that will arise. There are cases currently pending before the United States Supreme Court where we also have very robust, in fact, some would say increasingly robust protection of religious liberty, the expression of religious liberty. And in this instance, I would suggest that the Minnesota court will be drawn into multiple conflicts because religion, there is a principle that the most recently passed, when there's a conflict between existing law and a recently passed law, that the more recently passed law should carry more weight.
Senator Kroon.
Thank you, Mr. Chair, and thank you both for your responses. I appreciate that. I guess it kind of does highlight one of the big concerns I have about this is where we're basically just handing this over to the judiciary. That's how I see this playing out in effect. And certainly the ERA, I support equal rights for women, of course, absolutely. But this isn't your grandmother's ERA. This is, we're inserting hot button issues of the day that nowhere near have consensus by the people, and we're enshrining it into our Constitution and handing it over to the courts rather than letting the democratic process play out on those issues through the legislative process. And so, and one of the big ones that we heard a lot about during the testimony was biological males playing in girls' sports and how that could be, that right could be enshrined into the Constitution, where obviously is a hot button issue in society today. So I guess maybe my question could be to the bill author and just ask it point blank, would this proposed amendment enshrine into our constitutional the right for biological boys to play in girls' sports?
Senator Kunesh.
I'm going to defer to my testimony.
Jess Braverman.
I think these are all really important things to consider, and I think that's what's great about, we're all here today talking about the Minnesota Constitution. That does not happen enough. I'm not sure if this happens, maybe Professor Collette covers this in her class, but when I went to law school, no one talked about state constitutions. And so we have to understand like what this is and what it does. And so first of all, we're sending this over to the voters. So they would decide, the question is, do the voters get to decide whether or not these are the values of Minnesota or not? And so the voters will have a say in that, and everyone who spoke today will have a vote in that, and I think that's fantastic. In terms of what rights are and are not enshrined in this, what this requires is strict scrutiny when the government dictates certain things. So constitutional protections are nothing new. The court has to weigh in on these all the time. That's their job. That's why we have the system of checks and balances. The legislature passes a law, it harms a subset of Minnesotans. Minnesotans go to court and the judge decides, what do I do? That's really common. You see that every day. If that weren't true, I would maybe not have a job. And so strict scrutiny, which is what this requires, is it doesn't create policy, it raises the level of discourse. So if you want to discuss, let's say, a bill banning transgender girls from girls' sports, you'd have to come in with a higher level of debate and discourse than just this is something I don't like, I'm worried. There has to be more of a discussion of facts, data, why you're passing this law, which the court would then review and subject to what's called strict scrutiny, which is this a compelling government interest? And is there a way to meet the compelling government interest that has a less discriminatory impact? And so it's the same with religion, it's the same with other rights. There's a balancing test. And so this document doesn't say what laws are or aren't. They say like what level of discourse has to go on in order for the legislature to infringe on the rights of Minnesotans. The court might then look at the law and say this passes strict scrutiny. So let's say the legislature banned transgender girls from girls' sports, my organization may challenge that, but we wouldn't know until the court decides whether that ban passes strict scrutiny. And so I think the benefit of this actually is it raises the discourse because it makes the court look at it more carefully, which makes lawmakers have to debate the issue more carefully. So if you're going to harm a subset of Minnesotans, you'll have to be really clear on why you're doing that. And I think that's a benefit to everyone in the state.
Senator Kroon, I want to make sure we have time for Senator Westrom and Senator Westland on my list, anyone else, and we also may have some amendments.
It's just a
So I wanna
follow-up
make sure we have
statement,
time for that.
not a question. Thank you, Mr.
Senator
Chair.
Kroon.
And thank you for that response. Again, it was a pretty simple question, and I got a very interesting, constitutional analysis, which I appreciate as a lawyer, don't get me wrong, but it also goes to show that, yes, just because if this were to pass the legislature, it would go to the people for a vote, without a yes or no question on that, they don't really know what their vote means in that context. This is an issue that I think deserves the simplicity of the people through their elected representatives to have this discussion and to pass legislation that either allows for it or doesn't allow for it. And so again, this is just throwing it over to the courts. And you said yourself that if this passes, organizations like yourself would challenge any restrictions on biological boys playing in girls' sports. and then it would be up to the courts. And that's the kind of thing I think Minnesotans deserve better than that. They deserve to have clarity on this issue through the democratic process. So, but I do appreciate the dialogue, and I will open it up to other members for discussion. Thank you.
From one constitutional lawyer to another, Senator Kroon. Senator Westrom.
Mr. Chair, thank you to the author. So why write all of this language in there? Why not just refer to persons? A person's a person. Is it not? The current Constitution seems to have done pretty good for long over 100 years. Why are you writing all of this, these extra genders and pregnancy? Why do you write all of that in and not just refer to it as persons? Because that's who we're trying to treat equally here.
Senator Kunesh.
Well, I would thank you both for the question. I would have to say that when we are talking about this amendment and you're asking why don't we just say persons, we need to be very explicit about who we are talking about when it comes to these equal rights. Because obviously, we have not all been treated equally all these years. Women have not been paid the same rate as men. They have not been given the opportunities as men. Any number of groups have been not given equal rights. And so that's why this is really important. The goal of this Minnesota ERA is to bolster the rights that currently for individuals and groups of people who do not have the rigorous protections, ensuring every person has equal access to that safety, dignity, and autonomy. So we know that there are rights out there already. We have the Human Rights Act that is very explicit in unique groups. But we are trying to, the goal of this amendment is to ensure that it's the people that don't have those protections that will be covered.
Senator West.
Senator Kunesh, by your own answer, you're indirectly telling us that all the groups that aren't listed in here then aren't going to be called out for the equal rights. So I think right on its face and with your answer, that should give us all concerns. Again, are you saying these groups aren't classified under, wouldn't qualify as a person under the word person? Is that what I'm hearing you say?
Senator Kunesh.
No, Senator Westrom, not at all.
I didn't think so, but then henceforth, why do we need all of these groups called out if they are persons, which I think they are? Your answer just sort of gave us a lot of reasons why they somehow wouldn't be. Otherwise, we could keep it simple and just get back to persons. But, Mr. Chair, I'm wondering if I could have the testifier from Shakopee Women's Prison. I forget her name, but I've got a question for her.
So I think what we'll do is ask the two witnesses that are sitting next to Senator Kunesh to return to your seats right now. And we will ask Jamie Ali to come back to the testifier table, if you wish to respond to Senator Westrom's forthcoming question.
Hello. Yes,
Senator
sir.
Westrom.
Ms. Ali, do I have that right?
Ali.
Ali?
Yes, sir.
Thank you for your testimony, and thank you for being here.
Thank you.
I'm just wondering if you would be able to share a little more insight with us. I was piqued with interest from your testimony. In whatever extent you're comfortably talking about it, so I'd like to qualify it with that. So please do not answer more if it's not comfortable for you.
Sure.
But could you share with us a little bit more, because I found it interesting, and from your testimony, that there's a biological boy or male in the prison as a transgender inmate.
Yes.
But one or more in those categories create fear and harm to you and others? Have you witnessed any physical harm or sexual assault or anything like that as an inmate, if you feel comfortable answering that?
Ms.
Yes.
Ali.
Yes, sir. Thank you for the opportunity. Actually, yes, I lived firsthand experience the entire time I was incarcerated at Shakopee. I believe with the other individual that was just recently sent to Shakopee, I forgot, but I believe Rebecca Delahunt mentioned the name. That would bring the total, I believe, to 9 born biological men being housed in Shakopee Correctional Facility right now at this moment. I have been incarcerated with all of them except the one that just recently got there. Elijah Berryman being one, Bradley Servio being another. One of the problems is it's not with how people choose to identify. These are biological men hiding behind a transgender identity with their own sick, twisted, perverted agendas. Sean Wingland, who is now back in a men's facility, was one of those examples. Sean Wingland had initially been convicted for child molestation of his twin 6-year-old daughters. He got to Stillwater and began dealing with retribution and retaliation as his crime, very quickly decided to say, now he identified as a woman, did the process, which is very lax, and was then sent to Shakopee. As soon as he got to Shakopee, he began having sexual relationships with multiple incarcerated women there. One particular woman whose name I won't identify, in the hopes that they were going to get her pregnant, and they were going to then sue the Minnesota Department of Corrections and all other entities for what they were calling the $1 Million Baby Scheme. Upon many of his times in and out of segregation for having these sexual relationships, DOC and all of them were aware of it, and that continued to make us in more fear because most of those, whether willingly or unwillingly, are known as PREAs. And there was no protection for us as a result of that. And after multiple sexual encounters, he was then finally shipped back to a men's facility. I don't think anybody was even aware that this happened. DOC and all of those responsible, Governor Walz, Attorney Ellison, swept it under the rug. The problem is not only that these are born biological men, these are predatory men. I was forced to live side by side in fear every second of every moment next to murderers, child molesters, child and sexual human traffickers, level 3 sexual offenders. I had to shower in the same rooms and areas as them with doors that did not lock. I am a survivor of sexual assaults, and that trauma was one of the most devastating things that I had to endure. Just because someone makes a bad decision one day and they end up in prison, it doesn't take away their value as a human being. It doesn't take away their right to be protected. It didn't take away my right or the hundreds of other fellow sisters that are still in Shakopee and across this United States that are living right now at this very second of my testimony in the fear of the what ifs. The what ifs have already happened, not here just in Minnesota, but all across the United States. The statistics would be staggering if I could pull them out and show them to you.
Senator
Mr.
Western,
Chair,
yeah, and then about 3-4 more minutes of questions, and then we'll open up the floor for amendments as well. If there are any.
Ms. Ali,
Senator Western.
did I hear you right? In some of the sexual encounters were willing and some were unwilling? Is that correct?
Yes, sir.
Ms. Ali.
And
Senator Western.
Mr. Chair, Ms. Ali, I just want to thank you for your testimony. What was being done at the prison to protect women, prisoners, from this potential harm, if anything? And that's my last question to you.
Thank
Ms. Ali, briefly, if you could,
Yes.
so we don't turn this into a
Yes, sir.
Department of Corrections.
Absolutely nothing. To answer your question, absolutely nothing.
Okay.
Absolutely nothing. There was nothing done to protect me or to protect us. Absolutely nothing. I had two options: to either continue to live this nightmare or to go into protective custody.
Thank you.
Senator Westland. Senator Westland passes.
Mr. Chair, I think I'm done
sorry.
for
Senator
this
Western,
moment.
were you not finished? Were you not finished?
I thought you said Westland, and
Oh.
she didn't hear it say anything, so I thought, well, maybe you did say mine. Her name and my name are strangely close enough that it sometimes confuses me in committee and on the floor, and maybe her too, I don't know.
We don't want to get into more confusion.
It happens to me all the time. Every time I hear your name, I hear my name. But, Mr. Chair, my question was around strict scrutiny, and I felt Jess Braverman answered it fine, so I have no question.
All right, Senator Westland has no questions. Senator Westrom, are you concluded at this time? Okay, thank you. We'll go to Senator Holmstrom, and then we'll open up the floor for any amendments.
Thank you, Chair. And forgive me, I'm the new guy. I have a follow-up question for the bill author from Gender Justice.
Jess Braverman, come on forward.
So I think I heard you say that one of the benefits of this bill was that these decisions could be further scrutinized in the judiciary where they could be clarified. Is that correct?
In a
Jess
sense.
Braverman.
Oh, I'm sorry. I'm not sure. I'm not used to how these rules.
That's
I'm
quite
also
all
like
right.
a new person.
We only do it this way so that the public record can show understanding of who's speaking.
And court reporters hate me because I talk so fast, so I'm going to try to work with this. So in a sense, so right now, anytime there's a claim that a statute violates the Constitution, that claim goes in front of a court and the court decides, does this statute, does this law, does this policy violate the Constitution? This would affect the standard the court applies when they do that. And so the legislature would have to be a lot more careful in considering the harm, the impact, the data, the facts, the things that they do in support of laws, and then the issue would go in front of a court to be adjudicated.
Senator New Guy, Holmstrom.
Thank you. Thank you, Chair. I'm only in my second week here, but it seems concerning to me that we are already considering legislation that will try to pass away power to the judiciary away from the legislature on issues as powerful and as concerning as the ones addressed in this bill. Senator Kunesh, why is it a boon to the people of Minnesota to hand it off to the judiciary as opposed to their elected representatives who can most accurately defend their positions?
Senator Kunesh.
Well, first of all, this ERA amendment would allow the people of Minnesota to decide, not for us to decide. And I think that's an important part of it, that we're taking this opportunity to the people of Minnesota to make that decision. I think that sometimes we make decisions not always in the best reference, and so I think it's really important that we allow the people of Minnesota to make that decision by voting on it as a referendum constitutional amendment.
Senator Holmstrom.
I'll end with this. So I hear that, and I understand what you're saying with it going to an amendment and everybody gets to vote. But we had a question, a pertinent question about women's sports, and we couldn't answer it here. So if we can't answer it after all the work that we've done on this, I don't think that the average voter is going to understand that answer. And we said that this is going to let the courts decide, not the people, not the judiciary. If you could address that further.
Senator Kunesh.
Well, obviously, we can't decide that in the legislature, right? We can talk about it, we can debate it, we can agree to not agree. But if we are talking about the actual law and the protection, then we probably do need that higher scrutiny through the judicial system.
All right. We're going to open up the floor if there are any amendments. Now's the opportunity. We're aiming for a conclusion around 2:30. Are there any amendments? Senator Holmstrom?
Yes, I'd like to offer Amendment A1.
Senator Holmstrom offers the A1 amendment. While it's being distributed, Senator, why don't you go ahead and describe your amendment?
Thank you, Chair Latz. So this would delete lines 18 and 19, which would remove the protections in the bill. The following language: making and effectuating decisions about all matters relating to one's own pregnancy or deciding whether to become or remain pregnant. I'll say The Declaration of Independence guarantees the rights of life, liberty, and the pursuit of happiness, chief among them being life. No serious scientific understanding can argue that a baby in the womb is not a human life. The bill, as written, will fabricate a constitutional right to abortion in Minnesota all the way up to birth. That radical position is widely opposed by the general public, and the proposed language in the amendment is deceptive. Minnesotans do not support unmitigated infanticide. I ask you for your support in this amendment. Please consider first your humanity before your duty to your own party. Thank you.
Senator Kunesh.
Thank you. So first of all, I'm going to tell you that I will not accept this amendment. And the line that we are talking about, lines 18 and 19, say, making and effectuating decisions about all matters related to one's own pregnancy or decision whether to become or remain pregnant. I think that is an individual decision. That is a human right decision, and it's important that that stays in there. So no, I would not accept this amendment.
Is there any further discussion on the A1 amendment? Senator Westrom.
Mr. Chair, I would urge members to support this amendment. I think Senator Holmstrom has made a good argument. We should not enshrine the killing of a baby up to the moment of birth, and certainly not in a constitution that would be essentially permanent. One of the testifiers, I thought, brought forth just a very practical argument. Why would we be enshrining an abortion up to the moment of birth in the Constitution? So I think this would be a reasonable and a good start in changing this legislation, because it's opposite of what we as legislators and we as human kind neighbors should be trying to promote in making law for the state. As a dad that had premature twins at 32 weeks, 7 weeks before normal delivery, be born and just celebrate their 20th birthday last month on January 24th, just about the same day as we had a rally here at the Capitol, celebrating life. Senator Kunesh, as one parent to another, I am telling you, they are viable babies and human beings at 32 weeks. And I have living proof of two glorious daughters that are very successful, very active, and bring a joy to life. And so we should not enshrine this kind of conduct in our state. We are better than that. And I just hope you will be more open to that as we value life around this Capitol, as the lawmakers preparing our state and positioning it for the next 50 or 100 years, and sending our values to those that come behind us. And I think this would be an easy amendment, but a shame if we don't remove it.
Senator Pappas.
Thank you, Mr. Chairman. I want to make sure to have time for our testifier who's sitting at the witness table. But I just want to say that it's really a situation of women being able to control what kind of medical treatments that they choose, as men are, and also being able to control their decision about whether they want to be parents or not, because that decision and childbearing, first of all, can be dangerous to their health, but also that decision to have children affects their whole economic outcome of their life, their future life. The cost of childcare, the cost of raising a child, how it affects their career, their ability to work and provide economically for their family. It's so complicated that we should not be in a position of forcing women into childbearing if they choose not to do that.
Senator Kunesh.
Yeah, and just to respond to Senator Westrom, I do value every child. I just became a grandparent of a set of twins this summer myself, who came a little bit early and needed a little bit of attention. I come from a large family of 13, which means I have 50 million nieces and nephews, and every single one of them, as well as my own children, is a celebration to me, and I value children. But I think, just as Senator Pappas said, this is a decision that should be made by the parent, and it should be done in coordination with their medical caregivers. When folks talk about these abortions up until 9 months, we know that that is not happening. And you can say that it happens. We ask for proof all the time of this, and never have I seen ever proof of abortions. If an abortion is happening at 9 months, then that's a birth. And I cannot imagine that there are people out there putting those children, taking their life at that point. And so this kind of rhetoric, this kind of, imagine make-believe information until we see it and see the data, is doing a disservice to yourselves as well as all the women out there that have to make really hard decisions when their life is complicated, when they have a child, when they have a fetus in their bodies that is not viable. Do we do that to the woman? Do we do that to that child? And so I think in this amendment and the need for it, we are allowing for the healthcare providers and the parents, we are empowering them to make the best decision in that circumstance. And the rhetoric around these abortions up until 9 months is just unconscionable.
Cantor, Havilio, and then Senator Holmstrom, and then we'll bring the A1 to a vote.
Thank you.
Senator Wallstrom?
Yeah? Oh.
I'm sorry. Okay, I respect that you wish to speak. I don't know if there are any other amendments coming, but we're not going to get to them if we don't close up the discussion on this A1 amendment. So I just want to make sure we have time for if any other members want to offer amendments. Cantor, Havilio.
I just want to add to this. I have 3 beautiful children, 2 at the University of Michigan. I love children. I am a fighter for children and children's rights and women's rights. And I just want to say I'm also a fighter for Jewish rights. And in Judaism, actually, we celebrated Repro Shabbat last week, Reproductive Rights Shabbat, the National Council of Jewish Women. And in that Shabbat, I talked about the fact that in Parshat Mishpatim, which is Judges, which after we get the 10 Commandments, we have a lot of laws brought down on us. And one of the laws is if a woman who is pregnant and she is hit and she miscarries, it is not a life for a life, because that fetus is not a life in Judaism yet. And since then, Talmudic law and Jewish law, you can ask most Orthodox rabbis too, it is the woman's life over the babe of the fetus, okay? And so I feel like this would impact on me as a Jewish woman and my rights to my body and my ability to say to a doctor that actually the woman's life in my religion is more important than the fetus, because that's pikuach nefesh, saving a life. So I am all exactly what has been said here. I don't see how many people are killing babies at 9 months. I know friends that have lost babies at 9 months, and the horror of that. But this impinges on my religious rights if you have that amendment in the ERA law that needs to be passed. Thank you.
Thank you, Cantor. All right, Senator Holmstrom, I want to give you the last word on your amendment. If you want to speak now, that's fine. If you want to wait, now Senator Westrom, Senator Limmer. If you tell me there aren't any more amendments coming, we can spend more time on this one. But if there are more, we're going to run out of time for amendments. So Senator Western. we
Mr.
got
Chair,
15
I'll be
minutes
brief.
before we're gonna vote.
Just needing to respond to Senator Pappas and Senator Kunish's response, which was justifying killing a baby that's viable if it's not been born yet, because you may not be able to afford it, you may not want it. There's other options like adoption. So I just want to point out what we're hearing here in committee and the difference between the proponents of this bill and what I think the value should be from the Minnesota legislature, supporting life. Senator Kunesh, your language doesn't say if it's viable, it can't happen. Your language allows it up to the moment of birth. No question about viability. Thank you.
Senator Limmer.
Thank you, Mr. Chair. Senator Kunesh, bringing your attention to lines 18 and 19 on page 1. If that language would remain in the bill and this amendment would pass in November's, in an election, how would the legislature be restricted from passing any legislation regarding abortion, or who would be eligible for an abortion in the future?
Senator Kunesh.
I'm going to ask Ms. Braverman to respond to that with her legal opinion.
Jess Braverman.
We have this interesting system where you can't sue the legislature for the laws they pass. So the legislature can pass any law, constitutional or otherwise. Legislatures can and do pass blatantly unconstitutional laws all the time, and there's not much consequence other than you go to court and you can get an injunction or you can get a declaration that the law is unconstitutional. So there's not really a way I'm aware of through a constitutional amendment like this to stop the legislature from doing whatever it's going to do. The issue is that we have a system of checks and balances where it's the job of the judiciary branch of government to make sure the legislature hasn't overstepped its bounds. And this provides guidance for the judiciary branch on how to deal with if the legislature passes some sort of abortion ban, if the legislature bans trans girls from girls' sports, if the legislature greenlights racial profiling. I'm just, examples like the ERA would address these things in terms of how the judiciary should handle it. And again, that is how we set up our government with 3 independent branches, and the judiciary protects the constitutional rights of the people. And so that's how it would play out. But no, the legislature could keep passing bills. They just might not be ultimately upheld by the courts.
Senator Limmer.
So, Mr. Chair, Senator Cruen, in his first questions about whether or not the judiciary branch would have more power than the legislature is in fact true. And take, for example, in recent years, there's been changes of public attitude toward abortion. I hear all the time women who are in favor of abortion telling me that they are not in favor of the 3rd trimester abortion. National polls have said 80% of women do not want 3rd trimester abortions. In the future, if this was a law in our Constitution, the courts most likely would uphold the merits of this provision. The legislature, even if they wanted to recognize in the future a prohibition of 3rd trimester abortions, it would be immediately petitioned to a Supreme Court, and this would be the law of the land. So in effect, the courts do have an abiding superior position when we're comparing the equal branches of government. And no longer will there be representation of the people in the legislative branch on that particular issue. This solidifies a policy or a series of policies, and it negates the future opinion of future generation of voters. And that's why I can't not support this provision.
Senator Holmstrom, final word on the A1 amendment.
Thank you, Chair. So I will say a few things were stated, and I want to have respect for the testifier spoke about a Jewish faith, and as a devout Catholic, I certainly understand bringing your faith into this, but this discussion, of course, isn't just about our personal faiths. This is about science. This is about understanding that human life is viable and is valuable from a very early stage. So I want to end by saying we discussed as well the reasons people might have an abortion in late abortions. 74%, according to Guttmacher Institute, of women who have an abortion say they do it for an economic reason. The last reason that's cited, the least common reason cited, is for health. So that's not really an honest argument, and I think we should consider that. Again, I ask you to first consider your humanity and then your political party in this vote. Please support the amendment, and I would ask for a roll call.
A roll call has been requested. There will be a roll call. Staff will call the roll.
Chair Latz,
No.
Vice Chair Verbatim,
No.
Senator Limmer,
Yes.
Senator Clark,
No.
Senator Holmstrom,
Yes.
Senator Kroon,
Yes.
Senator Pappas,
No.
Senator Seeberger,
No.
Senator Westland,
No.
Senator Westrom.
Yes.
There being 4 in favor and 6 opposed, the amendment is not adopted. Are there any further amendments?
Yes, I'd like to offer the A2 amendment, please.
Senator Holmstrom. While the A2 amendment is being distributed, please go ahead and describe your amendment.
Gladly. This would, on page 1, line 19, insert or, and then on line 20, remove the language, gender identity and gender expression from the bill. Now, of course, I want to take a moment for Jamie to recognize the inmate from, or previous inmate, to recognize the cruel and unusual punishment that you experienced. I'm so very sorry that that happened to you. No woman in Minnesota should have to go through that. That is above and beyond anything I can imagine. Oppression of female voices and opportunities is at an all-time high. In Minnesota, our daughters deserve privacy, they deserve equal rights, they deserve equal opportunities, and they deserve our protection. Poorly written, irresponsible legislation like this will achieve the opposite. This will result in more girls being victimized on their sports teams, like Class 4A high school softball players who lost their state title to a team with a male pitcher, who besides pitching 3 shutout games in the tournament, made the game categorically more dangerous for the girls on that field. Title IX was a hard-fought victory for our girls. Somehow, that is now under assault, and it's not my party leading that charge. We owe our daughters protection. We owe them a yes vote on this amendment. Thank you.
Senator Kunesh. Roll call has been requested, will be granted. Senator Kunesh.
Thank you, Mr. Chair. And the amendment asks to, on line 19, after the semicolon, insert or, and then delete line 20, and then delete a couple other lines on that. What we're talking about here we're talking about the line that addresses gender identity or gender expression, and those are 2 things that are integral to this piece of legislation. And so with that, I will say I do not accept this.
Is there any further discussion on the A2 amendment? Members of the committee only. Not seeing any further discussion, the clerk will call the roll.
Chair Latz,
No.
Vice Chair Verbatim,
No.
Senator Limmer,
Yes.
Senator Clark,
No.
Senator Holmstrom,
Yes.
Senator Kroon,
Yes.
Senator Pappas,
No.
Senator Seeberger,
No.
Senator Westland,
No.
Senator Westrom.
Yes.
There being 4 votes in favor and 6 opposed, the amendment is not adopted. Are there any further amendments? Not seeing any further amendments. Senator Kunesh, final word before we take a motion on Senate File 473.
Thank you for the chair and members for this really lively discussion. We, as a legislator today, have an opportunity to lead in a historic way by putting this question to the voters. And that is what we are attempting to do. Let's provide the certainty, stability, and fairness that every resident of this state deserves. It's time to pass the ERA and ensure that Minnesota remains a national leader in human rights and self-determination. This amendment is a shield for the vulnerable and a statement of our state's character. It strengthens our democracy, it protects our reproductive freedoms, and it ensures that Minnesota remains a leader in civic rights. So, members, I respectfully ask for your support to move this bill forward and give Minnesotans a voice on the future of their rights.
Senator Pappas.
Thank you, Mr. Chairman. Then I would move that Senate File 473 be recommended to pass and re-referred to the Committee on Rules.
A roll call has been requested. There will be a roll call. Clerk will take the roll.
Chair Latz,
Yes.
Vice Chair Umer Verbatim,
Yes.
Senator Limmer.
No.
Senator Clark,
Yes.
Senator Holmstrom,
No.
Senator Kroon,
No.
Senator Pappas,
Yes.
Senator Seeberger,
Yes.
Senator Westland,
Yes.
Senator Westrom.
No.
There being 6 votes in favor and 4 opposed, the motion prevails. Senate File 473 is passed and re-referred to the Senate Committee on Rules. Members, with regard to future meetings, we will not have a meeting on Wednesday, and as announced last Friday, we will not have a meeting this Friday. So our next meeting, no, such disappointment, Senator Limmer. One reason we're not going to have a meeting on Wednesday is because there are some bill proposals out there that have not reached stakeholder agreement or consensus that wish to keep working on them. So I'm going to encourage members to work with stakeholders and with council, to speak with your staff about submitting hearing requests so we get them, because we're not going to hear a bill if there's no request to hear it. There are lots of bills in the committee, and we'd like to hear them if they're ready. And we rely on committee members and staff to let us know that.
I have a good real estate bill. I'd love to have a hearing on it.
Senator Kroon, talk to your LA. With that said, members, thank you all for the respectful committee hearing today, and we are adjourned.